Good afternoon, everybody. Welcome to the program, the Navigating Program, U.S. Economic Sanctions, Focus on Russia. My name is Dave Johnson. I'm a partner here in the Washington office of Vincent and Elkins with my colleague, Elizabeth McIntyre. She and I co-lead the export control and sanctions practice here within the firm. These are our bios. You can take a look at those and you can have access to these materials when we're done. We can now start with the content on the next slide. We're gonna, the way we've set this up is we're gonna spend about the first half talking about just OFAC sanctions in general and some general sanctions concepts. We will have a little bit of Russia in that content, but the Russia content then comes primarily in the second half after we've laid the general foundational concepts. When we get to Russia, and this is just to preview where we're going, you will see that we are going to be talking about the whole menu of sanctions that the US government has placed against Russia. Full blocking sanctions against persons and entities. We'll talk about what those mean. Transaction restrictions that are targeting banking sector and new investments. We'll also talk about export control sanctions. Normally we would term export controls as a sanction, but in this case, the US government has put in sanctions as part of the export control regime against Russia. And that would include the export of luxury goods there. We'll talk about import bans, and then we'll talk about a number of other bans that kind of add to this sanction framework. Bans on Russian vessels coming into the United States, as well as aircraft, and then no trade in Russian-occupied areas, including what's been in place since 2014 Crimea. So with that, we can move to the next slide. Very quickly, I think it's important to lay the foundation about what's the relevance of U.S. sanctions. Well, they're relevant because they apply to all U.S. persons wherever you're located. So if you're here in the United States, they apply to you. If you happen to be traveling abroad, you're still subject to U.S. sanctions laws. And most of these sanctions are a prohibition against a U.S. person dealing in the sanctioned person's property interest. The sanctioned person is sanctioned, but the penalties would apply to the U.S. person. These sanctions apply extraterritorially to non-U.S. persons in some instances, depending on the sanction regime, and they can affect all types of business transactions. Now, when we look at Russia in particular, we have virtually every type of sanction that the U.S. government has developed over the years has been put in place in some form or another against Russia or leaders of Russia or companies, large companies in Russia. And one of the questions that we'll have in our polling questions is your feeling on the effectiveness of sanctions. But I wanted to point out right at the beginning that the Congressional Research Service has done some work on this, and they believe that these sanctions have had a tremendous effect. Negative 10% growth of Russia's economy, inflation up 2.5% in 2022 in Russia, unemployment forecasted now to go above 10%. But there is still concern for those looking to punish the Russian economy to try to get results and have them back off of the Ukraine situation. There is concern that they're able to make up a fair amount of this if they're continuing to have the ability to export energy. And we'll talk a little bit about what the U.S. has put in place in that regard. We can go to the next slide, and Elizabeth will take over now.
So as Dave said, sanctions work by restricting the activities of U.S. persons who are the ones who must comply. So U.S. persons include all U.S. citizens, permanent resident aliens, green card holders, and certain other protected individuals such as asylees or certain refugees. U.S. corporations, including their overseas branches, and any person physically located in the United States at the time of their actions. For some sanctions programs, U.S. persons are also inclusive of foreign subsidiaries of U.S. companies. Next slide.
And now this is where you'll hear a good, for those of you who are very familiar with sanctions, you've heard about OFAC, you know about OFAC, it's located within the Treasury Department. This shows you where OFAC is. The Office of Foreign Asset Control, and they are the entity that basically puts, once the president issues an executive order, OFAC puts in place the actual sanctions, sometime in the form of regulation, sometimes in the form of a directive. And you can see they are located there within the Treasury Department, and they have both administrative authority, licensing authority, and enforcement authority. We can go to the next slide. Speaking of authority, so what are these authorities and how legally does a sanction program come into place? We've listed here on this slide for you many, not all, of the statutory authorities that can be used by the president or that are themselves set a sanction into place. But the predominant one here is the one at the top, the International Emergency Economic Powers Act, IEPA. You'll hear that. Most of the sanction activity that you see now when the president issues an executive order, it's done under the authority granted to him in IEPA. The Trading with the Enemy Act, the one under that, has been used in the past. It was the foundation of the Cuba sanctions, but now most of the action you're seeing is coming under IEPA, which grants the president this fairly broad authority in the case when he declares a national security emergency. We can go to the next slide. So OFAC, remember 2 slides ago we talked about OFAC. This is a current list of OFAC's various sanctions programs. We've highlighted in red here so that you can see them, the ones that really relate to the Russian situation, which we're going to talk about today. The first of those is this Magnitsky sanction you see over in the right-hand column. As many of you may know, this fellow, Sergei Magnitsky, was basically a forensic accountant. He was brutally murdered in a Russian prison in 2009, November of 2009, after he uncovered fraud that was perpetrated, it is believed, by governmental officials in Russia. There's a fabulous book written by Bill Browder and Sergei was his accountant. He ran a fund out of Russia at the time before he was banned that talks a good deal about this background and ultimately what happened to Magnitsky. After that, really the next thing that happened were the Ukraine-Russia related sanctions down there at the bottom right-hand corner that talk about Crimea. That's in the March 2004 timeframe when the Russians invaded Crimea. We put in a number of sanctions to try to deal with that situation. And then after that, we had the election interference sanctions in September 2018. And now we're up to the Russian harmful foreign activity sanctions, which came into place about February timeframe in the run-up to the war. I think the invasion was February 24th. And then since that time, there have been a number of sanctions put into place in that program. Belarus, which is highlighted at the top left-hand corner, gets the honor of effectively being the follow-on to many of these sanctions, receiving the very same sanctions that Russia has because they're complicit in many of the activities. We can go to the next slide.
So a sanctions program begins when the United States needs to address a national security or foreign policy issue. Some of the examples are listed there on the slide, and most are under IEPA, as Dave mentioned, which requires the president to declare a national emergency that is necessary to address a threat originating outside of the United States to the U.S. economy or national security or foreign policy of the U.S. So before OFAC can issue sanctions under the authority of IEPA, the president makes that declaration in an executive order that grants the Secretary of the Treasury to go forward with the sanctions program.
And now we should have our first polling question coming up. If you could answer the question will be live for a couple minutes, and then we'll have the result and we can see what the results are. But we'd really like to gauge the audience right now on basically the background that we've got out there on economic sanctions and your involvement in this area. And as the returns are coming in, it looks like well over half are telling us that they have almost no experience and they rarely have these issues come across their desk. Following behind that is really B. About 35% of the folks are seeing these issues from time to time.
There are a number of executive orders that form the basis of the Russia sanctions program. As Dave said, beginning in 2014 was the Russia-Ukraine program. resulting out of the occupation of Crimea. So those executive orders are all listed there. Most of the restrictions on this slide really relate to activities of U.S. persons involving certain sectors of the Russian economy, not full blocking sanctions, although those were in place in some cases. But there were energy sector restrictions, as well as defense and materials sector and financial services sector sanctions under those executive orders that were in place prior to the present conflict. Next slide. So this is the additional list of executive orders that have been in place more recently, as recently as April for the current conflict. And the most recent one, the new investment ban, covers all new investment in the Russian economy. So this is short of a full embargo on Russia, but it's as close as there is in a sanctions program that's not there yet. Next slide.
And as we start to get Russia heavy, now you saw all the executive orders that have been issued that relate to Russia. We thought we'd start with what I think is really the last major new flavor of a sanction that has been imposed here dealing with Russia. There's obviously more blocking every day. By that, I mean there are people that get on the list that get blocked. But this was the last kind of major new flavor of a sanction. And in May, about a month ago, we put in place sanctions and prohibited U.S. persons, wherever located, from providing accounting, trust and corporate formation, and management consulting services into the Russian economy. There are some definitions you see there about these services. The idea here was to prevent Russian companies from receiving these services from U.S. persons, which would further degrade the Russian economy. There are two exceptions there at the bottom. You see one is an exception where if the entity located in the Russian Federation happens to be owned or controlled directly or indirectly by a U.S. person, this is a feature that is supposed to lessen the blow to the U.S. Owner of a company and just try to target Russian-owned businesses to take these potential services away from them. Again, this is effective June 7th. There is a wind down license, and Elizabeth will talk about licenses a little bit later, that allows wind down activities with respect to these types of activities, notwithstanding the sanction until July 7th. We can go to the next slide. So that was the new flavor. Now we'll get back to the sort of the tried and true, and the typical sanction that you see is a blocking sanction. And we'll go to the next slide. There, we can stay right there. We'll talk about what a blocking sanction means. Basically, a blocking sanction is when a person is put on the list, no U.S. person may deal in their property. And we have a number, and Elizabeth will talk about what that really means, but we have a number of people and entities who have been blocked already. You see Vladimir Putin up there, members of the Duma, cronies of Putin, the oligarchs have been blocked. There are major banks in the Russian economy that have been blocked. There are Belarusian entities and individuals who have been blocked because of their complicity. And there are executive orders that warn that there are blocking sanctions available for anyone who OFAC determines has operated in a number of sectors of the economy, including technology, defense, financial services, aerospace, electronics, et cetera. So this is an ever-growing list, and it is aimed at trying to debilitate the Russian economy and move the decision-making by Vladimir Putin and others to end the aggression in Russia. That's the ultimate goal. We can go to the next slide.
Right, and that list of sectors of the economy, it either comes from executive order or an executive order that grants the Secretary of the Treasury through OFAC to add sectors of the economy. So that list has grown through several of those actions, either determinations by OFAC or executive orders directly. So what does it mean to be a specially designated national, an SDN? These are individuals, entities, and vessels that are designated by OFAC and determined to have met criteria for SDN designation that's spelled out in the relevant executive order. So when a designation is made and it's published in the Federal Register, it will say which executive order is the reason for the designation. Sometimes it will even say the paragraph, which can tell you kind of the specific activity that this person engaged in that resulted in designation on the list. So some of the criteria for designation as an SDN include operating in the designated sectors of the economy, including the ones we mentioned on the prior page in the case of Russia, being responsible or complicit in certain actions that the U.S. is obviously trying to deter or include human rights abuses and things of that nature. The next two on the slide, materially assisting and being owned or controlled or acting on behalf of sanctioned individuals or participating in sanctioned activities, those kind of allow sanctions to reach parties that aren't necessarily directly involved, but have given some support or assistance or have conferred benefits on other sanctioned individuals. So that allows kind of an expansion of who can be sanctioned under the sanctions programs. And then terrorism and drug trafficking are other reasons for designation. Next slide. So the implications of being on the SDN list, as Dave said, U.S. persons are broadly prohibited from engaging in activities with SDNs and activities that benefit SDNs, whether directly or indirectly, which can come up in a number of unexpected ways. If you have an SDN somehow involved in a transaction in the background and you're going to take a certain action or not take a certain action that confers a benefit, that needs to be thoroughly assessed before you can proceed. Any U.S. person in possession or control of the property of an SDN must immediately freeze it and block it, hold it in an interest-bearing blocked account. It can't be transacted in after that point. And there's certain reporting requirements associated with that as well to OFAC. Property interests of an SDN include entities owned by the SDN, one or more SDNs and 50% or more. So this is known as the 50% rule on the slide. Any entity owned 50% or more by one or more SDNs is also considered an SDN, even if it's not named on the list directly. So when you're vetting counterparties to a transaction, you need to look into ownership to make sure that prohibition isn't triggered by the owners who are not listed, who are listed, but while the entity itself is not. Control is not included in that 50% rule, but it can be a separate criteria for blocking, as mentioned on the prior page. So if there's a non-blocked entity that an SDN controls or owns a portion of, but not 50% of for the ownership rule, we recommend caution when dealing with such entity because it may be sanctioned in the near future.
And before we go to the next slide, just a couple of quick points, because I think this is a segue into one of the questions. When Elizabeth talked about the 50% rule, we'll see this a fair amount in a diligent situation where if you're doing it now, if you're doing a deal and you need to know the owners of whoever the target is that you happen to be, if you're the buyer happen to be doing a deal, and it could get very difficult in Russia. That may have been more of an issue before these sanctions, because as Elizabeth mentioned a little bit earlier, we're now reaching total embargo status. Unlike a total embargo, they put a total embargo. This has been a kind of an accretive situation. There's very little way to maneuver now among these sanctions where there's activity that can happen, and that available activity is narrowing every day. On the topic of the 50% rule, I think it's fair to say before what we have now, there was a lot of hand wringing when you dealt with the oligarchs, and we have a question in the queue about, well, what is an oligarch? Basically, these oligarchs are folks that were close to Putin or close to somebody who gained a benefit of having industries within Russia divided up, and they became owners of large swaths of the economy when things were privatized. If you go to Bill Browder's book, you can read all about how this process worked and the corruption involved in the process. And so the U.S. government went after these folks, many of these folks, not all of them, but many of them, with the idea that, number one, the property that they have should not necessarily be their property, but number two, they might be a pressure point on Putin and other allies to try to change some behavior. And so that was a tool that they've been using here. And I think I wanted to kind of clear up the question about what is an oligarch before we went too far. And you want to go to the next slide.
dealing in property interests is the prohibition relevant to SDNs, and it's U.S. persons who are prohibited from dealing in those property interests. Property interests are very broadly defined by OFAC. It's a very large paragraph of a definition naming probably about 100 different things. So they include really anything intangible or tangible, money, trade, checks, contracts, any contingent rights, and including future interest in something. So it's a very broad prohibition in dealing with property interests. And sanctions regulations are drafted very broadly, basically to prohibit any type of benefit or access by the SDN.
So if you find when you're doing a transaction, doing a sale or anything else, and you have to do a lot of screening. So you either need a screening tool that are commercially available, or you go to OFAC's website and you can type in names, and they have a feature there that it can correct and compensate for different spellings. You have to be doing screening if you're engaged in international activities these days, and so in this case, particularly with Russia, if you do screening, you get a hit, you find that somebody is near the transaction or in the transaction. This concept of a benefit and dealing in the property interest is interpreted by OFAC to be a very, very broad concept. So the idea behind all of these sanctions is to really cut off the sanctioned party from economic activity. And so you have to, if you're analyzing one of these situations, you have to think about it in that way, that the sanction is not necessarily by OFAC to be narrowly construed. What they have been attempting to do with their definitions and the concepts that they pump into these sanctions is to make them as broad as possible. I think with that, we have our next polling question. And we'd love to get everybody's view on this. And the question is, how do you feel about economic sanctions as a tool for managing national security risk and foreign policy objectives? You know, you can go to the broad spectrum of cable news, and I think you can get all sorts of answers to this question. But we'd love to hear what you all have to say, and we'll kind of linger here as we start to get the results. And you want to talk a little bit about the results?
Yeah, so it looks like about half are saying right now that they can be very effective at protecting U.S. interests. About a quarter saying no real opinion, and the rest primarily ineffective. So that's interesting, and creeping up a little bit for being very effective.
And we have this one's interesting too, because we have a very, very small percentage of the people who really focus on sanctions having a significant negative effect of punishing U.S. business activities and interests. And I think there are some U.S. businesses who have been really harmed as a collateral effect of these sanctions, which is unfortunate. I will say this, though, having been in this area for many, many years, I remember when I was a younger associate in the 90s when we had Iran sanctions that were put into place. Those came in, and they came in overnight, and we basically had to fill out license applications for activity that was in progress to try to finish it up. Flash forward now to 2022, what you see OFAC doing, and they're much more attentive to this now, is they'll issue these licenses that are wind down licenses. So they try to lessen the blow to the U.S. Industry that allows folks to, even though the sanction was put into place, allows folks for a period of month or several months to wind down activities and get a softer landing. So no more is there the problem where you have to start filling out license applications immediately. In many cases, these wind down licenses that Elizabeth will talk about it a little bit more do that. We can go to the next slide. We are now still on our different types of sanctions. So we talked about blocking. We took you through the SDN, what that means, the 50% rule. Now we're on new investment sanctions, and we can move to the next slide to talk a little bit about new investment sanctions. And this was kind of a flavor of a sanction that really became important in the Russian economy after Crimea in 2014, there were a number of directives that were put in these sectoral sanctions that stopped new investment in various projects or activities. We, in this case, in the 2022 version of Russian aggression, the administration put in originally a new investment, new equity investment sanction against a number of Russian companies. But now, as Elizabeth mentioned earlier in the presentation, as of about April 6th, there is now a blanket prohibition against new investment in the Russian Federation by any U.S. person. So they started with this more focused new investment, new prohibition on new equity, and now there is a total new investment ban in Russia. We can go. Is there?
Yeah. Did you want to talk about a couple of questions before we move on?
Myself the eye test. I'm trying to figure out the one. Why don't we have a question? I love this one. I'm a kindred spirit, and I'm not going to tell you who the question is coming from, but there's a question that says, why don't they release the different orders and sanctions in layman's terms for those that don't really speak legalese? My family would tell you that I do speak legalese, and I will tell you that I am not alone in frustration sometimes with the way the executive orders are drafted, and then the way the sanctions are drafted. There's almost an OFAC code, I think, with some of the terms and the way that they've set up these sanctions. So I don't know the answer to why they don't, whether it's lawyers trying to impress other lawyers, but there's a history of this stuff going back to Cuba in 62, 63, that you can kind of see the same trend.
Right. And for a given executive order or determination, you really have to drill down and back and back and back to understand what it means. So the point is well taken. Another point about OFAC and how they operate is a lot of what OFAC does is post FAQs on its website and kind of regulates through website postings. So it's not just the executive orders and then the OFAC determinations under those, but then there's another layer of guidance that isn't necessarily officially binding, but that you would really be strongly recommended to follow. And that's the website postings that never did go through the rulemaking process that the Federal Register notices would have gone through.
And there is another question that asks, aren't many of the victims of the sanctions the Russian folks themselves? They have no ability to change Putin's actions. I think it is true that I think the Russian people are suffering greatly. And it may sound harsh, but I think that is one of the designed effects of the sanctions. I think there's an extension of that idea that says that then the government's conduct will change and they will pivot to a different approach. We could debate whether that's happening now or whether they've changed anything. And I think in the future, we'll only see if this has been effective. But what's very, very interesting, frankly, about the Russian situation is the way the entire world, with the exception of very, very few folks, have gotten behind these sanctions and are supporting the Ukrainians in this. So I think with that, we can go. Elizabeth, you want to take the next slide?
Yeah, sure. So on to the next sector targeting sanctions. These are the sanctions that in large part were in place before the new investment ban. Some of them have been superseded by that, but others are still the primary sanction in effect. So we've seen restrictions on transactions with Russia's central bank and Ministry of Finance and National Wealth Fund. And there are certain carve-outs to that and certain prohibitions related to that that are pretty complex to navigate. And restrictions on transactions with Sberbank was one of the first kind of bank-related sanctions, but that again has been superseded by Sberbank now being fully blocked. Import and export bans, which under a full blocking or embargo, as you might see with Cuba, Iran, North Korea, et cetera, that would be an import and export ban on all goods and services. But in the case of Russia, it has not reached that, at least yet. It might. import ban. The import ban applies to Russian crude and other petroleum products, LNG, coal, seafood, alcoholic beverages, and non-industrial diamonds, and other categories of goods and services may be added to that as well in the future. The export ban covers luxury goods, which there's a whole list of, and basically with the desire to keep high-end items out of the hands of oligarchs, essentially, cut them off from the fruits that they enjoy from the U.S. economy as far as fashion and other luxury. Also a ban on dollar-denominated banknotes, cold hard cash. And Commerce and OFAC are authorized to add new categories to the list for the export ban. There's also a ban on approval, financing, facilitation, or guaranteeing of transactions that U.S. persons can't themselves participate in. And I think Dave will talk a little bit more about that in a couple minutes. But U.S. persons can't, in other words, facilitate a non-U.S. person to participate in an activity that the U.S. person could not undertake directly. Then again, new investment ban on the energy sector has been superseded by the broader new investment ban. One of the earlier measures was restrictions on primary market transactions in Russian debt, and now has been extended to secondary market transactions. And there's been a ban on Russian aircraft entering and using U.S. airspace, as well as trade and investment in the occupied areas of Ukraine. And the point with this slide is just the incremental and increasing nature of the different kind of sector targeting and different types of targeted bans that have been in place.
There was a question that relates to some of the content that Elizabeth went through, but also content prior that I went through on the new investment ban. And the question was, is that a ban on all sales to or business with Russian entities, private or state-owned? And then the follow-on question is, how is this less than a full embargo? There is not a ban. So the new investment ban is not as broad as I cannot sell a widget to Russia. It is still possible in some circumstances, although we'll get to the export sanctions in a little bit, but it's still possible and in some circumstances to make a sale of a product to Russia. Those circumstances are very narrow at this point, but it's possible, and therefore there's not a full embargo. There are other barriers to making those sales, obviously. How can you do the financial transaction? Because you can't deal with banks, or banks that you could possibly deal with can't get transactions to work internationally. So there are a number of barriers. So when the question is asked, how is this not a full embargo? It's not a full embargo because there's no full embargo like we have with Iran or we have with Cuba. But in many cases, it is not possible to do a particular transaction, either because the article that you want to sell can't be sold, the service you want to provide can't be provided. But if it could, there are other barriers like financial barriers and transactional barriers that may prevent it. So that's a long-winded way of saying we're coming. Some people may say this is a full embargo, but it's not, because there's still some openings in the fabric.
Yeah, and I think the key point with new investment is going to be looking at whether there's an equity interest that you're obtaining there. So, that's kind of what that focuses on.
Yeah, and we can go to the next slide. So in trying to kind of organize this set of sanctions, this was kind of a little bit of a one-off. There is now a sanction against Russian-affiliated vessels. We tucked it in the sector sanction, but some may call it an animal unto itself. There was a proclamation on April 21st that by the president that basically prohibited Russian-affiliated vessels from entering United States ports. So what we are not talking about here is a vessel that has a Russian crew, okay, many vessels have Russians working on the crew of that vessel. That is not necessarily a Russian affiliated vessel. What we are talking about is any vessel that is Russian flagged, any vessel that is Russian owned, if it happens to be owned by an oligarch or by a Russian company, and any vessel that is Russian operated. And that does not mean necessarily by a Russian crew. That means that a Russian citizen, company, or permanent resident is responsible for the commercial decisions of the vessel. So it will say, take that cargo and we'll sign this contract to transport this cargo wherever. That is the definition of a Russian operated vessel. None of those vessels that meet these criteria are permitted to come into U.S. ports. There are some very limited exceptions. One is that we have some activities related to nuclear byproduct material with decommissioning and those sorts of things. There can be an exception for a Russian vessel carrying that type of stuff under these agreements to come into U.S. ports. And in addition, if there's a sort of force majeure or life safety issue where some vessel needs to come into a U.S. port, that's accepted out of that order. But the idea here is it's just another incremental sanction to cut Russia off as much as possible from the U.S. economy and as a collateral effect from the world economy.
Next slide. So now we're going to turn to the export control imposed sanctions. And as Dave mentioned a couple minutes ago, export controls were typically not considered to be sanctions. They're more to protect U.S. national security interests by keeping certain technologies out of the hands of other countries and things of that nature, rather than more punitive as a sanction. So next slide. The sanctions that have been administered through the export controls program are administered primarily by the Department of Commerce, which is the regulator for commercial and dual use items, including commodities, materials, software, and technology. And Commerce has been coming out with a number of escalating restrictions in the export space, just as OFAC has in the traditional sanction space. So any item that is on the Commerce Control List administered by the Department of Commerce under the Export Administration Regulations now requires a license to Russia, even if, based on the item's characteristics, it doesn't for the particular item. The fact that it's even on the list at all now supersedes that licensing requirement specific to the item, and a license is required. Commerce has also expanded its jurisdiction over non-U.S. items that it maintains jurisdiction over that are produced abroad, but either contain a certain amount of U.S. origin technology or software or produced directly from it. The list of items that Commerce can now control for export that are not produced in the U.S. has been expanded when those items are destined for Russia or Belarus, compared to when they're destined for other countries. These rules are even more complex, in my opinion, than many of the OFAC rules. And if you have any commercial or dual use items intended for Russia or Belarus, it is a very complicated process. And those items, as I said, include software and technology as well. Earlier rules really stuck to the more sensitive technologies on the CCL. So these expanded rules have really enhanced the jurisdiction of the Department of Commerce, kind of to regulate exports beyond what were earlier included. And then there are licensing requirements for any exports destined for military end uses or military end users if they are even not on the Commerce Control List, but otherwise subject to U.S. jurisdiction by being U.S. origin or otherwise.
We have a question that I think is very much on this slide, Elizabeth. The question is, are, quote, no license required, unquote, items considered to be on the Commerce Control List or the CCL?
So if they're no license required because they are designated as EAR 99, then they are not on the Commerce Control List. If they're no license required because for that particular ECCN, a license is typically not required, that it's still on the CCL.
Yeah, and one of the things I think we can back up a little bit on is that for those who are not familiar with the Commerce Control List, we have primarily two export control regimes in the United States. We have arms export control regime, which is administered by the State Department. We're not talking about that here. We have the Export Administration Regulation, which is administered by the Department of Commerce. That's what we're talking about here. That regulation is a very, very big regulation. It has what is called the Commerce Control List, which has 10 categories of items. They start with category 0 and they go to category 9 with a list of specifications. And those items that fit within those specifications, mostly performance specifications for various types of items, would be on the Commerce Control List. If they're on the Commerce Control List, they are controlled for export to at least somewhere other than the terrorist countries like North Korea and Iran. So what we're talking about here, when Elizabeth just says if it's EAR 99, an EAR 99 item is not classified on the Commerce Control List. So my pen is an EAR 99 item, could be exported to Russia without a license. Other items that are on that CCL list, which is a huge list, takes up my phone, would fit on the CCL. Okay, those would require then the license.
Right, and your pen could not be exported to a military end user in Russia or somebody who's supporting military end uses in Russia.
And I wasn't intending that to happen.
I hope you don't do that.
Yes. Before we go though, we have another, I'm sorry for interrupting the export. We'll jump back real quick to the vessel question. We had a question here, what about a non-Russian owned, so we're not talking about a Russian vessel that has been going in and out of Russian ports for the last 6 months regularly, unloading and loading goods, and now wants to come into a U.S. port. The prohibition does not ban that vessel from coming into a U.S. port. There may be restrictions on importing what it's carrying. There may be restrictions on the vessel coming in if the vessel is owned or controlled by a blocked person or if the vessel itself is blocked. But the ban that we were talking about coming into U.S. ports was specific to that Russian-owned or Russian-flagged vessel. So the question that has been asked here about this non-Russian-owned vessel that's been going in and out of Russia, that creates a bunch of risk. And if you've got one of those vessels that's going to come into a port, obviously you'd be screening the vessel, you'd be screening the ownership of the vessel, the vessel may have issues because of what it's carrying, could not be imported because of the import bans that we talked about earlier. Is there anything you think I'm missing on that question that we should add?
No, I think that covers it. But like Dave said, vetting the owners and the contents of the cargo, all of that, it would be a necessary step. And the last point on the export slide relates to aircraft that are subject to U.S. jurisdiction. I know we mentioned on one of the prior slides, Russian aircraft being prevented from coming into U.S. airspace, but aircraft are an item generally on the Commerce Control List as well. There are exceptions available for flying an aircraft from the U.S. to a foreign country. That is considered an export of the aircraft. And so the U.S. has really cracked down on aviation-related export controls involving Russia and Belarus. It's published a huge list of aircraft that have flown into Russia without a license when one was required. And any servicing or provision of maintenance on those aircraft is also prohibited. And that's with the goal of grounding those aircraft going forward. And those are Russian registered or owned or leased aircraft that are still subject to U.S. export jurisdiction. And therefore, the Department of Commerce is able to regulate the export from one country to another of those aircraft. Next slide. Dave mentioned earlier licenses. You can go on again to the next. So OFAC issues both specific and general licenses. A specific license permits an individual, an applicant for the license, to engage in otherwise prohibited activities on a case-by-case basis. That requires going to OFAC, explaining the circumstances of why the activity by the U.S. person, the applicant typically, should be allowed despite literally being prohibited under the regulations. And it is considered on a case-by-case basis, and it may be granted in limited situations that OFAC will say, for the purposes of continuing a certain transaction or providing a certain service, you are authorized to do this limited set of activities. And OFAC also administers general licenses, which are posted on its website under a given program page for its sanctions programs. At the present time, it has issued about 40 or more general licenses with respect to Russia since 2021 under the different Russia sanctions programs. General licenses include a limited authorization to engage in, again, certain categories of transactions that are otherwise prohibited. But unlike a specific license, it's available to anybody who meets the criteria for using the license, and you do not need to go to OFAC to ask for permission to use it, as long as you meet the criteria and comply with any reporting requirements that are necessary to allow use of the general license. So that may include making a report to OFAC within 10 days of a certain trigger point, and not doing so would be a violation of the terms of the license. So those reporting requirements are important to keep in mind. The categories of transactions that may be authorized include wind downs of existing activities by a certain date. Oftentimes, as that date approaches, OFAC will reissue the license with a new letter after it, going from A to B to C, and in some cases far on down the alphabet, extending the wind down date to allow U.S. companies to continue winding down long-term transactions that can't be accomplished within a month. There are also general licenses available for providing certain agricultural commodities, medicine, and medical devices to Russia. And these general licenses are typical of other sanctions programs too, but we're specifically talking about Russia with these examples. Non-commercial personal remittances to Russian individuals, family members, and things like that are also authorized generally. And then other examples might be certain intellectual property activities needed for either maintaining or asserting patent rights. Certain credit rating and auditing service activities are also authorized under a general license right now. And then pension payment activities are another one. And then that's just a couple of examples, but basically, there are about 40 right now in place that authorize certain activities with Russia. And
I was going to say, if I could add something on the wind down, Elizabeth mentioned how often, maybe not often, but in many cases, these wind downs are extended to allow U.S. companies to continue the wind down. We have seen a few situations where it is believed that the reason the wind down is extended is that OFAC is making progress with the sanctioned entity on some aspect of why it was sanctioned. So if it happened to have an SDN as a owner or somebody who controlled the entity and that person was divesting themselves, we have seen situations where that is being actively worked with OFAC, and the sense is that the wind down license is continuing to be extended because OFAC is seeing progress in that. So they've sanctioned the entity, allowed a wind down period. Whatever the bad thing is that caused the entity to be sanctioned is being dealt with, and OFAC has given some flexibility, and if they see progress, has extended the wind down.
And yeah, exactly. On the last bullet point on the slide, the Commerce Department licensing, that pertains to the exports that we talked about in the prior section. So Commerce can issue an export license when we say that a control is in place or an item can't be exported to Russia under the current controls. That means it cannot be exported without a license. You can always ask Commerce for a license when there's a licensing requirement or a control in place. In the case of Russia and Belarus, though, most of the licensing requirements have a policy of denial associated with applications.
One more thing on this slide before we get to another polling question, which I don't think we've mentioned this dimension of kind of practicing in this area and dealing with economic sanctions. But the Office of Foreign Asset Controls, and this is entirely different than what, for all the lawyers on the video, when you took administrative law in law school, you learned that there was rulemaking, notice and comment period, et cetera. And so that's how administrative law is made, and that's how the process works. OFAC has done a fair amount over the years, and I can't really remember when it started. It started sometime after they got a website, but they have a practice of doing some interpretive activity through frequently asked questions. So in some FAQs. So in some cases, somebody from industry will ask a question, they'll get the same question 4 times, and then they'll create a FAQ asking the question, then they'll put their answer, and then they'll put it on the website. I think we're up to well over 1,000 FAQs. So it's become kind of a body of interpretive law, so to speak, that's on the website, which would cause my administrative law professor probably to really start to twitch. But for some of these concepts, and in particular with the general licenses, because we go back to the question that was asked earlier about, and I think it was a question, but it was also making a point. There's a lot of legalese and terminology that OFAC likes to use that in some cases somebody may say that seems to be more complicated than it should be. The FAQs in some cases can be helpful in unpacking some of that language and getting to the point where they'll define a term through an FAQ, or they'll describe what a particular activity means through an FAQ. So if you're dealing with a GL and there's something about it that doesn't make complete sense, there is a chance that there has been some administrative activity in the FAQs or some other advisory opinion, and they do publish advisory opinions from time to time that deals with either the GL or the sanction itself. Did you have anything else you wanted to add to that?
No, I think that covers it.
Okay, and that'll bring us to our third polling question. And this is the predictive. So we've taken you through, we started this thing, and then we've taken you through this, and now we're getting towards the predictions. And this is where we have some real value coming out of those on the other end of the video feed. Do you think the accretive sanctioning that the U.S. has imposed on Russia is having or will have a positive effect in bringing an end to Russia's invasion of Ukraine? Did you want to comment?
Sure. Yeah, it looks like about half right now are saying they are starting to have an effect on Putin's activities, but are not there yet. The next most popular right now is that they have done nothing.
And there are 11 people who have no strong opinion on this question. I wonder if they're the 11 who have great involvement in sanctions and a lot of experience in sanctions, and they just want to sit on the sideline. But I think the idea here going into these sanctions was this is set up to have some effect. Obviously, if you look at, I think, before and after pictures of Putin, if we probably put it side by side when he was early February and where he is now, he's a man who looks a little different. So maybe that's a helpful thing. There's also the situation that nobody knows, and I think some people are wondering if it's going to move the needle, if there are those around him who are getting totally frustrated with the situation and the end game here, that these sanctions are going to start having an effect. So we've got now we've got 56% of the folks that believe they're starting to have an effect, and we've got another 11 who feel that they've had a positive effect. So that's 66. We've got a full quarter of the audience who believe that they've had sort of a negative effect in just hardening Putin and the cronies. So we'll see where that goes. I'm hopeful that it's going to be in A or B when we look back on this stuff, but we'll see where it goes. We can go to the next slide. We'll now just do a couple cleanup slides, and Elizabeth and I kind of dive in on this. She'll probably interrupt me a couple times, and we'll take you to the end. But the first topic on compliance and enforcement we wanted to talk about a little bit was, and it's somewhat, I don't want to say it's unique, but it's a big factor in economic sanctions issues and law. And that is that most of the executive orders you see and all of the regulations practically that you see from OFAC coming out have an evasion and avoidance and facilitation component to them. And by that, it means that a transaction by a U.S. person that evades or avoids or tries to evade or avoid the sanction prohibition is itself prohibited. Now, this gets to be a little bit of a murky situation, but if you're a lawyer and you're an in-house lawyer or an outside lawyer that advises companies, I mean, one of the kind of the bright line rules is you can always give legal advice as to whether an activity is compliant or not compliant with the sanction or poses risk, obviously. What becomes much more difficult is when people are trying to kind of create situations where they can do an activity tomorrow, which they are barred from today because of some circumstance. The typical example of this would be, and this happened in the Iran sanctions early on, is where a company had a policy in place that would require the vice president in the USA to make a determination as to whether a business transaction can go forward for a subsidiary over in Europe. That subsidiary then had an Iranian transaction, and under the policy, they needed to talk to the vice president in the US. That person, of course, couldn't be involved or would be a violation of sanction. The US company was not prohibited in taking down that policy or procedure in order to let the transaction flow. That would have been a violation of this principle. That's a fairly clear example. There are obviously others on the margin. And then facilitation by a person, a U.S. person is illegal. You can't facilitate. You can't let things happen that otherwise couldn't have happened. You can't refer a matter that you couldn't do because of sanctions somebody who could.
I was just going to say on that point about facilitation and evasion and avoidance, there is a fine line too between taking steps to comply and taking steps to evade. And so I think that transactions often need to be looked at carefully to determine which side of the line you're going to fall on. If you're trying to make sure you're structuring something in a way that will be compliant, the flip side of that could be an evasion issue. And the facilitation issue by U.S. persons, a lot of companies will just have in place a policy of complete recusal by their U.S. entities and U.S. persons. If they're foreign entities who are not U.S. persons can do it, they can't involve the U.S. side of the business at all.
And now we're coming up on time. We can go to the last slide. This is the pucker factor slide. This is why if you're a lawyer or you're a compliance person, you want to go back to your company, this is why, one of the reasons why we comply, okay? Stiff, extreme fines and penalties. Willful violations are criminal, $20 million imprisonment for up to 30 years. You've got the sanctions under IEEPA. This is why IEEPA is used often, is because the penalties are higher than some of the other statutes. And then you see some other activities there. You also have other effects and possible bad outcomes, including suspension and debarment, cease and desist orders, and OFAC and BIS from Commerce are often double teaming on these issues. And with that said, we're at the hour. Thank you so much for being a great audience. We like all the great questions. If you have anything further, please reach out to Elizabeth or me. You want to say anything?
Thank you very much.
Goodbye.